Great. Okay, so I will propose, welcome everyone that is already in the room. I will propose we just give like maximum of 5 minutes
Sure,
to the latecomers, then we kick off at 10:05.
no problem.
All right, good. And welcome everyone. If you don't mind, feel free to actually just share your name, your company in the chat. It's also a platform for networking. Share your details in a chat. You never know, someone will be in the group that will find you as a partner. Welcome, everyone. Thank you for joining in. Thank you, thank you, thank you. You're so welcome. I'm sure we're going to have fun today. So we're just waiting 4 more minutes, then we'll be on our way.
Madeline, if you're chatting, I think you're on mute, maybe?
Oh, sorry. Yes, you were right. I was on mute. I was on mute. Okay. No, thank you so much. Thank you, everyone, for this first session on the legal series that RWA is providing in partnership with Legal Ninjas. So today we are going to cover introduction to business contract and IP, intellectual property, and with our facilitators, Tyron Blignot and Sinamisa Mayo. So, this is a very interactive session. I would like to request everyone, please put your questions in the chat, put your comment if you have anything that you would like to know about the topic that we'll cover today. Please feel free to use the chat. We will constantly be checking on the chat to see if there's any message that our speakers could address. But before we invite our speakers, let me just give you please just give us a 1 minute to introduce you to Leading Women of Africa, what we do, what our services, and also the activities that we're busy with. So, Antioch, can you share something with us? Great. Thank you so much, and thank you for watching. So please feel free to follow us on social media. Feel free to join as a member, join some of our events. Actually, this coming Thursday, we're going to have a free event on G20. We need to speak about G20. Feel free to really be part of us. And we would like to really welcome you as a partner, as a member. Please feel free. I think Antioch will share links on the chat. And yeah, we would like you to be part of the LWA family. Now we invite our facilitators, Taryn, Mr. Moyo, over to you and the audience. Please, like we say, put your comment in the chat, your questions at the end before they take over. At the end, think already, as they are talking, think already the next topic you would like them to cover in the next session. So you can share in the group. I think it will help them to know your needs or our needs because we are all small business, as entrepreneurs and what they could assist us with during next session. Darren, over to you.
Thanks so much, Madeline, and thanks LWA for inviting us to speak today. I'm Taryn. I'm based in Cape Town, and I'm the founder of Legal Ninjas. Basically, we're a legal consultancy that is aimed at helping small businesses with all their legal needs, from business formation to all sorts of contracts, to IP, dispute resolution, basically everything that a business needs. That's what we do from a legal perspective. And we do this online so that we can offer more affordable rates. So we all work from home, and we're all big law firm and big corporate legal consultants that have chosen to have a more flexible existence after COVID. We all loved working from home. And now we operate online, and we provide legal services on a fractional basis to a number of our clients who maybe can't afford the big fancy law firms out there. So that's just a bit of what we do. And in terms of the pricing that we offer, we're also very flexible with that. So, if a client wants a fixed fee, we do fixed fee quotes. We also have an affordable flat fee hourly rate. And we do monthly retainers for larger clients that want more ongoing legal support every month. So say they want like 20 hours of legal support a month, then we provide them that for a discounted rate. So that's just about a bit about our consultancy. Sorry, I'm just trying to get the next slide. Cool. And then this is just a slide with a bit more information about us, the Legal Ninjas. So I'm a corporate, commercial, and financial services attorney with over 15 years of post-qualification experience. I've worked at massive corporates like 91, a big asset manager, and Coronation Fund Managers. And I've drafted pretty much every type of contract that exists. That's my speciality, drafting contracts. And then Sena is our trademark ninja, so he's going to be talking to all the intellectual property slides later on in the presentation. Okay, so let's chat about contracts. So firstly, I always get the question, why do I need a written contract? Isn't a verbal contract legally binding? Why do we have to write stuff down? And my point is always, yes, okay, technically a verbal agreement is legally binding, except for a few, formal contracts like the sale of a movable property where you have to have a written agreement. But most of the time, a verbal agreement is legally binding. But the problem is, how do you prove that you have a contract? So if something goes wrong down the line in your business relationship, and suddenly the other person just says, "Oh no, what are you talking about? We never signed a contract." How do you now prove that there was even an agreement? Another difficulty comes in with remembering what you actually agreed. So, years may have passed, you don't have anything in writing, you might even have forgotten exactly the scope of the services or, how long was the contract meant to be in place for and all that sort of stuff. So I always say, it's really not worth having the risk of having a verbal contract. Put it in writing and, also make sure that it's actually very detailed. So, a one-pager contract is really not worth, you may as well write on a napkin, honestly. It's not worth it. You have to have more detail than that. It can lead to disputes if you don't cover all the various topics that we're going to be talking about in terms of contractual framework later on. Because if you don't agree upfront to all the details, then it just leaves a lot of vagueness and openness for interpretation and scope creep and all those things. So firstly, let's chat about what is a written contract. So firstly, it's a binding legal agreement between two or more parties. So you can have more than two parties to a contract. For example, a tripartite agreement has three parties. Each party commits to doing certain things, their obligations, and also maybe not doing things like, for example, not disclosing confidential information that they learn out of the business relationship. And the aim of the contract is to create clear rights and obligations for each party. So one party will have the right to payment, the other party will have the right to receive services or goods, for example. And it also enables the enforcement, the easy enforcement of that right and obligation, because now you've got proof. You can say, look at clause whatever it is. This says that you need to do that and you haven't done it, so therefore you're in breach of contract. So that's really what it's all about. And then providing clarity and mutual understanding upfront is very vital to business relationships. You don't want to have a situation where the obligations and rights are vague, and then that just creates, a huge risk of dispute later on. So the more detail you can put in the contract, the better. And it also forces you to actually chat about these things upfront and make sure that you're on the same page, you have a mutual understanding of what's going to be going on under this business relationship. And, it might create a bit of awkwardness up front when you're negotiating the contract, but rather have that than later down the line when you have a complete misunderstanding and you actually realize you weren't on the same page. So, yeah, another benefit of having a written contract is that in the contract itself, you can set out how you want to regulate disputes if they do arise. So, usually, what we would recommend is that you have multiple mechanisms of dispute resolution. Firstly, obviously, just amicable attempts to resolve the dispute with your key representatives, and failing that, then you move on to the more formal dispute resolution proceedings, which we'll also cover later in the presentation. And then another important thing with having written contracts in place is that it future-proofs your business. So it's actually an asset to your business to have all these contractual relationships solidly in place. And one day when you want to maybe sell your business, the first thing that a party is going to do when they're looking to buy your business is to do a legal due diligence on your business to make sure you actually have these contracts in place, that there's no huge risks involved in taking over your company. And it shows investors that want to maybe invest as shareholders in your business one day that you take yourself seriously and you're professional, and you've put everything in writing. So it really is very important. All right, and then what makes a contract legally binding? So, firstly, you need to have legal capacity to enter into a contract. So, for example, children cannot enter into a legally valid agreement. You need to have legal capacity, you need to be an adult of sound mind. And if you are representing a company, you need to make sure that you are authorized to sign on behalf of that company. And this is something I see all the time, where the secretary ends up signing an agreement and you like, well, where's the board resolution that authorizes you to bind the company? And they're like, oh no, actually I don't have the authority, sorry, I'll get the director to sign. So you need to also make sure that when you're signing an agreement, you're the one that's authorized to do it. Sometimes a board resolution will also require that two people sign on behalf of the company so that there's oversight, and that a director doesn't suddenly go rogue. So then you would both need to sign for the agreement to be legally valid. Then the terms need to be clear, and the parties need to be clearly intending to be bound by this agreement. So, for example, a memorandum of understanding, an MOU. Often people think this is a legally binding contract, but it isn't. So that's kind of a precursor to a legally binding contract, which is a memorandum of agreement. So MOUs aren't actually legally binding. They're just kind of this is what we're thinking of doing together in our business relationship. This is our idea going forward. And, if we're on the same page under this MOU, then we're going to enter into an actual formal agreement. So that also needs to be clear. The purpose of the contract also needs to be legal. So you can't enter into an agreement, someone says, I want you to kill me, please, kill me on this date. Obviously, that is not legally valid. It needs to be within the scope of the South African law or whatever law in your country that you're in. And then in terms of formalities, there are certain agreements where you actually have to have things very formalized. So, for example, a will, because there's a risk of people trying to, get your money when you die or whatever, they make sure that there's witnesses in place that are signed, that they've witnessed that you actually signed the will and it wasn't someone trying to defraud your estate. Sales of immovable property, same thing. It's such a big transaction in your life that that also has to be in writing. It has to be initials. Everything needs to be very formal. But generally, you really can just have a written contract and sign at the end. You don't have to initial each page. You don't have to have it witnessed. It's just a signature on the signature page. Okay, and then in terms of price, this is a big one that I see often. You can't agree to agree later on to the price. It needs to be clear in the contract itself what is the price or how is it going to be determined? So if it's not a set rand value or, whatever currency value, you need to at least put in the contract how it will be determined. So is it an hourly basis? What is the hourly rate? How is it calculated? That level of detail also needs to be in the contract. And then, yeah, I just also note here an agreement to agree is invalid. So any agreement to agree is not valid. So you really need to force yourselves to negotiate upfront and put all the level of detail in the contract. And then obviously you also need to make sure the contract is signed. I've also seen this many times where people send me an unsigned shareholders agreement wanting to enforce their rights. When I ask for the signed version, they say, oh no, it was never actually signed. So, I mean, that's literally worth nothing. So you have to make sure that both parties sign the agreement and that you save it somewhere safe. Okay, so these are just a few of the types of contracts that are very important to every business, depending on your size, depending on who owns the business, etc. So, for example, employment contracts, the minute you have employees, you have to have an employment contract in place with that employee. If you have freelancers, you should have an independent contractor agreement to regulate what services they're providing, what you're paying them, when you're paying them, all that sort of thing. Services agreements where you're selling or procuring services. If you have a website type of business where you're selling things online, or any sort of website really, then you should have terms and conditions of service that is on your website and regulates the contract between you and anyone using the website and anyone that is buying your services from there. Then non-disclosure agreements, NDAs, secure confidentiality. So sometimes you will not need to enter into a separate NDA because you already have a confidentiality clause in your main contract. But if you are going to be chatting to someone about something that's potentially confidential or you want to keep under wraps and you haven't yet got to the stage where you've actually executed your main agreement with them, then that's when it's a good idea to get them to sign an NDA. Yeah, and then in terms of shareholders agreements, this is a big one that often gets missed. So if you have more than one owner of your business, it's very important to have a shareholders agreement put in place to regulate your relationship as shareholders. Who is doing what in the business? What happens if one of you wants out and you want to sell your shares? Do you first have to offer those shares to the other partner before you can offer it to someone else? What happens if one of you dies? All of these things you need to think about for succession planning in your company. So that's also a vital one. And then if you have office space, obviously commercial lease agreements is important. And then there's all sorts of funding agreements, so loan agreements, financing docs, if you're ever getting, funding from an investor. If you want to sell your business, then you can, do a sale of business agreement or a sale of shares and claims agreement. So you can see there's a wide range of contracts that are needed as you progress in your company. Okay. So this is the contractual framework that should be in place across all these types of contracts. These are the like non-negotiables that you really want to put in all your agreements. So firstly, the parties. You have to identify who are the parties to the contract and not just their name. Who are they? Where are they located? What is their ID number or registration number if they're a company? And who is the key rep from that company that you're going to be liaising with? Especially if it's a big corporate, then you really need to specify who is the person that you're going to constantly be liaising with from their side. Otherwise, you don't even know who to contact from their side if something does go wrong or you don't get paid or whatever. Email address and phone number also is a good idea so that you know how to contact the other party. And then in terms of setting out what is actually being sold under the contract, is it goods or services? what exactly is that? So you can put, I'm going to provide IT services to this company, but what does that mean? What is involved in the IT services exactly? Are you going to be selling Microsoft Azure products? Are you going to be doing cybersecurity checks? It needs to be detailed so that there's no scope creep later on from the other party saying, oh no, but I thought you were also going to do this for that price. And then suddenly you're like, oh crap, now I haven't protected myself and I have to suddenly do this extra piece of work for nothing. So you really want to protect yourself by being as detailed as possible. And also be able to, if you're the one that's procuring services, you want to be able to hold that person to account. So be able to say, you were meant to send me a report by the 15th of this month, and you haven't done it. So you really want to have detail in there so that you can say later on, you haven't delivered this, or you're performing poorly under the contract because of this. Okay, and then you also need to regulate how long is this agreement going to be in place for. So is it a fixed term? Is it literally a 3-month agreement? You're just getting a temporary services for your company and that's it. You can put a fixed term in there. If it's a much more ongoing type of relationship, then you can just say that the agreement kicks off on a certain date, whether it's signature date or a specific date in the future after that. And then you can say, okay, it's going to just endure until it's terminated by either party in terms of the actual termination clause. And then in that termination clause, you will say, okay, you need to give written notice of, say, 60 days to terminate, for example. Um, and you also need to think about what makes sense from a termination perspective. How long would you need in terms of written notice? So if it's like a service you're procuring that's vital to your business, if you don't have it, your whole business falls over, then you probably want a longer notice period for termination so that you have time to get a backup service provider. So things like that you need to think about. And then also just the procedures around termination. So do you just send an email to terminate the agreement on a certain date? What happens after that? Do you need to hand over documents or property? Like if using a laptop of the company to do the services, you might want to put in there that you have to hand over all that stuff. You need to keep things confidential even after termination. So that's also something to think about. And then pricing and payment terms. Obviously, this is a crucial part of the contract. You really want to put as much detail in as possible. How is the price determined? Is it a fixed fee for the whole project? Is it an hourly rate? A monthly fee or retainer? Do you charge per product that's ordered? All of that needs to go in there. How does the invoicing work? Do you invoice upfront at the beginning of the month? Do you invoice on a quarterly basis? How long after they get the invoice do they have to pay you by? Can you charge interest on late payments? And very importantly, if you are the one supplying the services, I always recommend you put in a clause that says you can down tools if you're not paid, especially if the payment is very late. Like you've given them a reminder and they still haven't paid you, then you need to put a clause in there that says you then allowed to down tools because otherwise you're just forced to carry on working despite the fact that they're not paying you. So that's always a good one because you know, it's going to prejudice them for you to stop working and they're going to be much more likely to start paying you quickly. And then what happens if someone disputes the invoice? Is there a process that you've set out for disputes? Like, within 5 days, you've got to discuss and make sure that you're on the same page with the invoice, etc. And then obligations of each party. I've chatted about this already, but basically put as much detail as possible, like including report back meetings, what you expect the other party to do from beginning to end of the contract. Obviously they need to cooperate with you and act in good faith, but what else do you expect them to do? Um, and then POPIA is obviously a big one in South Africa, data protection. Um, Under POPIA, you need to have consent from the other party to be able to process their personal information. So it's always a good idea to put that in the contract itself and say that you each consent to the other person processing your personal information and that of your staff, etc. And how you're going to process the information. You can just say, look, we'll comply with POPIA because, to be honest, most of it is already in the Act. But if you have a more sort of technical service like cybersecurity, where it's really like paramount that there's data protection, then you may want to go into more detail about the technical measures that you're taking to make sure that that data is not leaked to unauthorized people. Confidentiality, that's another one that should always be in your agreement. And then, from that point onwards, then you don't need a separate NDA to cover that. And IP is another one. If there's anything to do with intellectual property, like the service involves you actually creating IP for the company, then you want to detail who owns what IP. And you'd also want to say, look, you will own the IP that I create for you, provided you've paid me for the services. So you only get session of that IP once you've paid me in full, because that's another mechanism to protect you against non-payment. And then breach and dispute resolution, that's very important to put in your contract. I always recommend that you include provision for arbitration in your agreement because the courts are a hot mess, especially in South Africa, and it's much more efficient and less costly to resolve, horrible disputes via arbitration as opposed to going the litigation route. Um, and then liability is also very important to cover especially if you're the one that is providing the services, because you need to think about what is the potential for things going wrong here. And given the size of your business, how much risk can you take on? So always limit your liability to direct losses, losses that are caused directly from your breach or your negligence or whatever the case may be. No indirect losses, because that just immediately means you're going to court. Because how do you determine what the losses are if there were, a loss of reputation to the company that's involved, etc. And then I always think it's good to include some sort of cap on liability if you can, so that you know what's the maximum amount you're going to be paying if something does go horribly wrong, and link that to the cap under your business insurance if you do have business insurance, which I obviously recommend. So then if something really goes wrong and you're negligent in some way and they come after you, your insurance payout is the max that you're going to have to pay them. And then notices, that just is the clause to deal with any notices under the agreement have to be sent to, whoever the key rep is. And then obviously your signature page for where you sign the agreement. And then these are some important clauses or things to think about to mitigate non-payment if you are the service provider or the supplier of goods. So obviously, wherever possible, get a deposit up front before you commence work, because this already shows you the person's serious about the business relationship. They want to move forward. They're not just saying they're going to pay you. Anyone can say that, but they're actually putting their money where their mouth is. And then if you're paid on a monthly retainer basis, it's always a good idea to get paid up front, because there's usually like 14 or 30 days in which the other party can then make payments. So by the end of the month, then they've paid you. And you don't have to worry at the end of the contract about that last month when you've now left the building or stopped the services. You don't have to then stress that they're not going to pay you your last invoice. For very large transactions, you might be dealing with a huge risk to your business if it's like a huge tender that you've won or something and you've got millions coming your way, but now you want to make sure that they're going to pay you. You might also want to look into an escrow agent to actually hold the funds in escrow so you know that they're there, and then that gets released once you deliver the services. And then obviously enabling yourself to charge interest on late payments is a good idea. And having a clause in your contract that says that the director of your company must just sign a certificate to say what is owed under the contract, and that immediately makes the claim a liquidated amount of money because that allows you to go to court for summary judgment, which is quick and easy. It's like they can't dispute the amount that's involved. Another good one, if you are dealing with, a larger sum of money, is to include a clause which allows you the option to at least go to the magistrate's court in South Africa if you want, because that's obviously a lot cheaper than going the high court route. Um, and yeah, then you can decide, okay, do I want to do arbitration or do I want to just go to magistrate's court and risk getting a crap magistrate, which is the other risk. But at least then you know you're not going to have to go to high court because high court in South Africa is just where dreams go to die. And then in terms of suretyships and guarantees, if you are wanting security from the other party that they're going to perform, and maybe it's a new company that's just formed, you don't know much about them, it's a bit of a risky counterparty, you might want to get the directors to actually sign a suretyship to say they're also on the hook. If they don't pay you, then you can come after them as directors. And a guarantee is the equivalent of a suretyship. It's just that it's in the form of a company that's guaranteeing maybe the subsidiary will pay you. And then we've also covered retaining ownership of IP until paid in full. Okay, are there any questions at this point in time? I haven't seen any in the chat. Should I just carry on? Okay. Okay, and then doing business with big corporates. Um, I mean, this is always very exciting. You get a huge contract or award from a big corporate, but the risk here is that if you're a smaller business and things do go wrong, then it can actually ruin you. So you have to be very careful when dealing with big businesses because they obviously have these big legal teams and they have their standard contract templates and they're going to try bully you into signing everything that is in their favor. So my advice is treat them like any other person you're negotiating with and make sure that you have a very clear scope of services so that there's no scope creep because they love that. And make sure that you get a deposit up front wherever possible, or you make sure that the payment terms are at least, within a reasonable period and favorable, or that you get, milestone payments. So you're not just waiting and waiting till the very end for your payment, especially if you have to fork out money upfront for this contract. If they play hardball, you can too. You're also a party to the contract. And, if you think that the contractual terms are impossible and unfair, and they're just being very, very hard about everything, then you can actually just walk away. I know it's very hard when you get awarded such a big contract and it's so exciting to grow your business, but is it worth the risk? You have to think about that. If the contractual terms are not fair, that's also a bit of a red flag. It shows that they're not really respecting you as a contractual party. Um, and then obviously you want to put in there the key rep that you're going to be dealing with at the big corporate and that you can down tools if they pay late, because that's a big one for them. They love paying late in big corporates because they don't need the money. They've got millions in the bank, so they somehow think that you do too. So that's also something to think about. And then obviously the retaining ownership of IP is a big one for that too. And then in terms of negotiating contracts, firstly, you must know what your non-negotiables are up front. There's certain things in the contract where you might like, this is a nice to have, but it's not vital for my business. Then you can negotiate those points and maybe give in to the other party if they want something a bit different. But if it's a non-negotiable for you, like for instance, you have to be paid by a certain time, otherwise your business is going to fall over, or you have to get 50% upfront because you're going to be forking out a whole lot of cash upfront for an event or something, then you just say, this, sorry, this is a non-negotiable for me. I can't do it otherwise. Because the sooner you get that across to them, the better. Because you might find that actually then it's not going to work. There's not going to be an agreement. So the sooner you realize that, the better, the less time you're wasting. And then if you're going to be signing their contract templates, obviously it's always good to have a legal review of that. You can review it yourself, of course. You can see if there's a glaring risk involved, but there might be some other things in there that you don't pick up. So, if it's a big transaction, I always suggest you get a lawyer to at least review the contract, make sure that it's equitable and it's not totally in their favor. Um, and then be open to compromise. Obviously, every party always wants things their way, but you have to also think about why are they asking for this change? They might have a valid, reasonable reason for that from their side. So you do also have to be respectful and try not to get emotional when it comes to contract negotiation. Okay, and then disputes do unfortunately arise even with contracts. So you need to anticipate that that might happen at some point, especially if it's a longer term business relationship. Um, and to think about disputes, you have to also look at the contract itself. So put in your contract that these are the different dispute resolution mechanisms. First, we're going to try amicable chats. Then, if that doesn't work, if it's not such a huge dispute that we're still collaborating, we still want to work together, but there's just this niggly thing that keeps coming up, then you might want to go the mediation route. Mediation is not legally binding, so that's something you just need to keep in mind. But it's to have an independent party come in and say, look, this is actually unfair, you need to do this, or maybe come together in a different way. Having that third party come in and see things from a fresh point of view sometimes helps to resolve a dispute. But if things get ugly and it's adversarial, things are getting a bit nasty, you're maybe not sure you even want to carry on business with this other person. That's where arbitration comes in because you're going to have a professional, a lawyer usually come in and look at the facts of the matter under the law, under the contract, and decide the dispute as if he was a judge. It's the same as going to court, essentially. It's legally binding. Um, Litigation itself, going to court, I would say, is your last resort, especially in South Africa. The courts are just the delays are sometimes years. It's super costly with the lawyers. You can run hundreds of thousands of rands in legal bills within a few months. So that's really a last resort, unless it's a quick proceeding. Like sometimes you just want some sort of urgent relief, like to stop someone from, an interdict or something like that, then maybe it will be appropriate. But most of the time, litigation is just going to be a nightmare. So here's an idea of the different dispute resolution mechanisms and the costs involved. As you can see, the costs are quite extensive, especially when you hit litigation, can run in the millions of rands. So that's also why I say it's really a last resort type of thing. And this also explains to you why it's so important to have a clear contract so that you try and resolve things up front before you even start your business relationship, rather than leaving it till later and then having this costly exercise of resolving disputes. All right. Are there any questions? Let's have a look here. Is it just in South Africa that MOU isn't legally binding, or is it? No, this is the norm everywhere. So MOU stands for Memorandum of Understanding, not agreement. So it really is like the precursor to an agreement. It's where you don't really want to be legally bound. You're just kind of like exploring a business relationship or a collaboration. And it's kind of like, okay, let's test things out first under the MOU and see if we like working together, and then we'll enter into an actual agreement later if we're happy. That's kind of the idea behind an MOU. Okay, and signed by all, what if the MOU is signed by all parties? Yeah, same thing. It's not meant to be a legally binding agreement. So you can sign it, you can witness it. It's just going to be there as proof of what the understanding is. But it's not something that you can really go to court with and say, you know, help me, they're breaching my MOU. I really, to be honest, most of the time MOU is a bit of a waste of time. I really just recommend going straight to the agreement phase. Okay, what's the general process of amending an existing contract? So, in most contracts, almost all contracts, there will be a clause that says non-variation. And this is the clause which specifies that nothing that if you verbally agree to change in the contract is valid. It has to be put in writing and signed by the parties for it to constitute a formal variation of the contract. So, you need to do an addendum to the agreement, which sets out exactly what changes you're making. So it will literally say, you know, from this date, clause 10.1 will be amended to say this, and clause 55 will say this. And you put every single amendment that you're making, you put in there. But there are also ways to future-proof your agreement a bit. So, for example, like pricing, you can say, okay, this is the price, but on an annual basis, the price will increase in line with the CPI. So then you don't have to every year now do an addendum to update your pricing. You can just increase the price on an annual basis. So there are ways around doing addendums, but often for like any material changes to the contracts, like, a huge change in the scope of work, you're going to need to do an addendum for that. Okay, I think that's all the questions for now. So I'll hand over to Sena. Oh, wait, there's one more question here. If someone litigates against a business and it runs out of legal funds, is there free legal representation available? No, no. I mean, if you commit a crime and you are, in court, the state is prosecuting you, you have the option of a free legal counsel from the state. So the state might give you a lawyer to represent you in the criminal case. But yeah, no, trying to get a pro bono lawyer with litigation on civil matter, good luck. Just if you run out of money, best to just withdraw the case, which is why I've made those points about how important it is to try and avoid litigation because it can get super costly very quickly. And the problem is even if you win the case at the end of the day, they might award you costs, but the actual costs that you've incurred will be a lot more than the costs that the other party has to pay because those are according to a court scale and are often much less than what the actual lawyers are charging you. So you might still end up with hundreds of thousands, if not millions, in legal fees that you have to pay out of pocket, despite the fact that you won the case. So litigation is really a bit of a nightmare. The only people that make the money are the lawyers. Okay, Sena, you're up.
Thanks, Aaron. Hi, everyone. By way of introduction, my name is Sena Misomoyo, but I prefer Sena. It's shorter, easier. Just by way of experience, I've got experience in intellectual property law. I've worked at some of the leading law firms in the country that do trademark law and copyright. And I've also worked in-house, and I'm now supporting Taryn with the trademark stuff and the intellectual property side at Legal Ninjas. So one of the big sort of experiences we found is when businesses are starting up, IP protection is often overlooked. That's just because I understand spending on legal is a grudge purchase. It's like insurance, that thing that you don't want to pay for, but you have to pay for it, and it's often very expensive. And that's when we come in and try to make some of these services accessible and try and advise in terms of how we can assist with intellectual property and how best you can protect your ideas and your business. So we'll start off with what is intellectual property. I often say when my parents ask me, "Oh, so what do you do?" I'm an intellectual property lawyer. And immediately people think, oh, you mean like houses and real property that you can touch? That's not the case. Intellectual property is intangible property. So that's creations of the mind. So anything that you create from your mind that you can't hold, that's your intellectual property. So think your music, your logos, your brand names, your businesses, all of those things which are valuable inventions, literary work, artistic symbols. All of those are what we call intellectual property rights. So what you can do with intellectual property rights is obviously once you have either registered intellectual property right or you have acquired an intellectual property right, I'll get into what that means in a little bit, you're able to enforce them against other people. And for the benefit of many small businesses, you're then able to control whatever innovation it is, or it's an image, or it's a logo, or it's a brand name. You can license it, all for the purposes of generating revenue and making a profit. So some, pardon me, some levels of intellectual property is protected. So you need to go to a specific office or a body to register it. And then others is accrued and it comes into being automatically. So I'll maybe start by going into the different types of intellectual property. So the first is copyright. I'm sure we've all heard the term copyright, or we've seen it at the end of the movie. Copyright in this film vested in Universal or Disney or Netflix or whoever it is. So copyright is the right to a creative work. So it can be a book, like I said, it can be a movie, a song, artwork, anything along those lines which you've created. It has to be original and then expressed in material form. Those are the requirements. A trademark, we'll speak mostly about trademarks, I believe, today, but a trademark is the IP related to your brand name, your logo, or your slogan, basically anything that identifies your business. So you'll see Coca-Cola has, the red Coke logo. They've got that Coca-Cola in cursive. They've got the red color. All of those things are what we call brand identifiers. They're the badge of origin for Coca-Cola. Other similar businesses, Colgate, they've got a very strong trademark. Nike, Adidas. And then if you want to, maybe you've come up with an idea, you start your business, it's usually advisable, very advisable to seek trademark protection. So we can assist with trademark registrations on an application basis where we can file your name or your logo with the CIPC to make sure that no one steals it or uses a name similar to yours. So we'll get into the details of that as well. There's also patents. So patents is the registered right to an invention. Very technical and incredibly complex and at times costly. But the thing with patent law is it's your inventions. So basically you created something new, very inventive, never been seen, technical. You can apply for a patent. The big software companies and the big law firms, sorry, not big law firms, the big cell phone companies, computer companies, or the big science labs, they invest a lot in patents, the universities as well. Trade secrets, very important in the food industry. So these are rights to commercial information that's confidential and integral to a business, like the Coca-Cola recipe or the KFC recipe. We only hear that it's a couple of spices, but we don't really know what they actually are. Many have tried to reverse engineer that, but that's an example of a trade secret. I myself prefer the Nando's recipe. If I can get my hands on that, I'll be very happy. And then you've got designs. So designs are the registered right to an aesthetic product design. So if you look at your car, the shape of your car, that's a protected design right. And whenever you see the new BMW with the new facelift, BMW actually goes to register the new design of a new hood, a new bonnet, just basically a new shape of a car in general. So that's an introduction to intellectual property. It's protection of the mind, and it's split into, I guess you can say, 5 main childs of IP. Very important that we try where we can to register and in some instances, make sure we secure protection. So there's different ways I think I mentioned to protect IP. The first is contractually. So Taryn mentioned earlier that, when you're involved in negotiations with big businesses, or with any business, to be honest, it's very important sometimes to include confidentiality obligations. Now, this is not just so that people don't discuss the terms of the deal, but it's also so if you have a good idea, you're a software, developer, you're going to a big business and you pitch, and you don't want them to steal your idea and run off with it, which is something that we see, quite frequently, where someone says, "Oh, well, I pitched to a big business, and next thing I saw them advertising, my service offering or my software product." Now, very important to make sure that in the agreements that you have with all these entities, you include confidentiality obligations, like Taryn mentioned. I prefer going to the point of going to a very broad NDA that, sort of enforces the rights very clearly to say, look, you will not disclose my idea. You will not talk to anyone about this. This is just for the purposes of funding. Very, very important. That's a very straightforward way of protecting your IP from, from theft. It sounds very simple, but maybe when you're now very excited to get into the boardroom with the big businesses, it's very easy to sort of give away the whole farm. So that's one way of doing it. The next way of doing it is through registration. Now, I mentioned registration of IP in relation to trademarks, patents, and designs. So I'll speak very quickly with regards to that. So the CIPC has a process that allows us to register all your trademarks via the CIPC. What this means is if you come up with a business name or a logo, even before you've started using it, we can assist you with the process of getting the rights registered via the CIPC. So it takes about 18 months to you to get a full registered right, a registration certificate. So would file the application via the trademarks office at the CIPC. They would examine it, and then eventually, if they believe that there's no one else who's currently using that mark, or that your mark is capable of distinguishing, then you'll be able to register a trademark and get a registration certificate. Now, you can have a TM next to your trademark when you use it in trade, even if it's not registered yet, just to tell people that you are laying claim to that right. But it's always better to go to the registration route so you can get the R. The R is stronger than the TM that you'll see next to a name. Patent registration is also something that we can do via the CIPC. So you can register your inventions and your ideas. And that's including anything that has a technical creation, a technical innovation that'll be applicable in trade. Specialized lawyers are required to do patents in South Africa, so we need to refer you to a patent specialist who will be able to review all the technical aspects, just to be able to inform you that, well, this is registrable and maybe not. Just continuing on how to protect your IP. So we spoke earlier about trademarks. So if you've got a registered trademark and then you find that someone is using a mark that is similar to yours in trade, or they're stealing your getup, or they're using colors similar to yours, very, very important that you monitor and let your attorney know very quickly if you see someone who is using, your brand name or your logos, or you see counterfeit goods without your authorization or permission. Acting quickly. In this day and age, the counterfeiters move very, very quickly. So if maybe you start a business, you might be able to see that as you gain more traction online or you become successful, someone else is already trying to replicate it, creating social media page, mimicking your business, creating websites, and even stealing your domains. Very, very important that you act quickly. Legal letters do work. We find that people are scared of cease and desist, so that's an option to take into when you identify someone who's infringing on your rights. Litigation. Taryn mentioned earlier that the courts in South Africa are a mess, and that is very, very true. IP is just as much. In fact, all IP matters, just because of how technical they are, they go straight to the High Court. As you can imagine, that becomes very, very costly to manage. It's always best to consult an IP attorney just to discuss any of your prospects of success if you see someone using a brand name that's similar to yours, just to see what options are there. Like I said, it's always better to have a registered right. Now, I mentioned this with trademarks. If you have a registered trademark, you pay the sort of fees upfront. It's always easier to consult or to confront third parties with, hey, I have a registration certificate, stop using my trademark. That is better than now having to go through the courts and trying to prove a lot of things. Cool. And next slide. So one of the things that the trademark examiners at the CIPC do, so when you then come up with a name and then maybe you approach us to assist you with registering a trademark, when we apply to register the trademark, the examiners at the CIPC will review it and they will check against existing marks on the register. The reason for that is to try and see if there's no one else who's already claimed that name. There's no one else who already has legal ninjas. So we would probably, if you'd come to us to say we'd like to secure a trademark, one of the things that we suggest is conducting a search on the register. So we have ways of accessing the CIPC and conducting analysis on the existing marks just to see if there's anything that's similar or anything that would be a blocker to your registration. Then we would provide you with a full report to say, these are all the marks that we've identified. This can include logos that are similar to yours. This is what I think we can do. Or we didn't locate any risks. You're fine to go ahead and register the trademark. The reason for that is because I think the trademark registration process is quite lengthy and expensive. You would rather sort of do that due diligence ahead of time just to identify whether or not someone is using the mark, or if it's available or not available, or if you need to approach them for coexistence, or to choose a new name altogether. It's always very important to kind of get as much information first, because I think your trademark does become the identity of your business. And for many people, it becomes a commercial asset. They can license, they can trade, and so forth. So like I said, if there are no major objections, we'll proceed. The application is usually about 9 months. And then if sometimes the examiners don't refuse the mark, but they might have a few concerns, queries, requests. They might ask for more documentation. That happens within that 9-month period. It's 9 to 12 months, to be honest, at this stage. They do take a bit of time at the CIPC, but the good thing is if you register your trademark today and they maybe take 18 months to issue a registration certificate, your registration is valid from today. So your rights would be backdated from the date of application, and you would have it for 10 years, renewable every 10 years. So like I said, in total, it will take about 18 months. There is no guarantee that an application will be successful. As indicated, the examiners at the trademark office can, in some instances, decide to refuse trademarks. They can make further requests, but that is something that we can deal with as and when it arises. Also, onto copyright. So trademarks are the brand identifier. So that's what identifies your business. It's your name, it's your logo, that's your badge of origin, it's who we are. Copyright, like I indicated earlier, your creative works. So your works of art, your music, your literary, your music, novels, and even software codes. So the codes that are written for certain programs, those are works of copyright. And they are licensable, and you can commercialize them. You can sell them. I think a lot of people do deal with a lot of licensing of software to big businesses. That's a work of copyright which is commercially exploitable. So it comes into creation automatically. So if you create it and you express it in material form, you have the right. With copyright, there's no need to go and register it, unlike trademarks. So trademarks, it's very, very recommended that you go and you register a trademark. With copyright, it's slightly different. In South Africa, once you make the work of copyright, you release the song, you write the book, you write software code, the work comes into existence and you have your rights. The difficulty is obviously enforcing them and proving them. That's why it's very important that you have your work of copyright in material form. And that's why a lot of movies at the end will have the C sign to say copyright in this work. It's for Warner Brothers, it's for Disney, it's for Universal, so that they can lay claim to that work to say it's theirs. And oftentimes they'll put the year, because if someone makes a work at a later stage which is similar to your work, you can say, no, I made it earlier, it's my work of copyright. So it's limited to the work itself. If someone is using your work as inspiration to create their own original work, so if someone is just inspired by your work and then they create something which is original, it doesn't look the same, in that instance, it's not copyright infringement. So I hope that's clear in the difference between trademark and copyright. One of the things that, sorry, before I go into the case studies, that you can do with both. So with registered trademarks, once your trademark is registered, very important that you're able to enforce your rights. And by enforce your rights is now you have the registration certificate. What do you do? And there's many things, many options that you can do. So you can now online, especially nowadays in the days of Takealot, Alibaba, Facebook Marketplace, Instagram, you can actually even register your brand name, and those sites would do takedowns for you in respect of anyone who's infringing on your business. So in the modern day, that's very, very useful. And if you have registered rights, it's very easy to go to the courts as well as the police to do seizures and takedowns and seizures of counterfeit goods, or take down domains that are similar to yours. Now, in those scenarios, if you had an unregistered trademark, it's not to say that you wouldn't have protection, you would, and you would still be able to enforce your rights. It just becomes more difficult because without the certificate to say, this is my trademark, it becomes very difficult if you've been using, let's say you've been using a brand name for 10 years and someone infringes on it. If you don't have that certificate, you'll need to prove use. You have to prove for many years that people identify with your business, which is, like I said, it takes more time, it's more expensive, and needs lawyers. Whereas if you have a certificate, it's much more straightforward. So there's very nice examples of cases in South Africa that have gone to the High Court. We have a very, very good sort of IP court system. Some of the cases that come across our courts are quite interesting. One is Checkers versus Pick n Pay. I'm sure some of you are very, very, very familiar with the forage olive oil. So Checkers has had this on their shelves for many, many years. Well, maybe a couple of years. And Pick n Pay a few years ago also released their own extra virgin olive oil. Now, in this regard, they tried to, well, you can see that they took the get up from the Checkers olive oil. This went all the way to the courts with Pick n Pay arguing that, look, the ordinary consumer would not be confused by these two and would not think of any association between the two businesses. The High Court decided that no, it's quite clear that Pick n Pay had let's say, borrowed from ShopRite Checkers, and they had created a GetUp, which is similar to theirs. Now, this doesn't deal with registered trademarks per se, so you'll see that here, Pick n Pay didn't really use any specific name or logo that is the same as the ShopRite Checkers olive oil, but they did steal what we call the GetUp. So they were passing off their product as if it's a ShopRite Checkers product. So they were found guilty of infringement. In this regard, Frankie's is a business. I think they've been around for a while. Smaller business that used to make soft drinks. Woolworths, if you look at the root beer bottles, especially Woolworths started selling bottles with a similar.
It's not working. The new one.
Oh, sorry.
It's not working. Green.
So root beer.
You could maybe mute.
No.
Auntie Osh, please mute them.
No
worries. Cool. So with Woolworths, Woolworths has started selling bottles similar to the Frankie's in design, in getup, and just in the style. So this also didn't deal with specific registered trademark, but it dealt with how a business presented itself as another. In this case, Woolworths had, let's say, borrowed as well from Frankie's, which is an established old business. This is another one case which is known as the David versus Goliath cases in South Africa. There's quite a lot of them that involve chicken licken. So if you just go and Google, look at the chicken licken trademark cases there, they're all very fascinating. So Woolworths was found guilty to have stolen or borrowed the idea and the getup of Frankie's. And they had to sort of remove their soft drinks from the shelves. But these are all examples of IP law. It's not necessarily tangible products, but it's creations of the mind, it's ideas. It's a getup, not necessarily the actual straight trademark to trademark copy. But it just shows you how people can try and copy your ideas in different ways. And it's very, very important that you're able to commercialize them. And then we were obviously able to assist you with that. Yeah, I think that's it. I'm not sure if there are any questions.
I thought maybe you can also chat about geography of the trademarks. Like if you have one registered in South Africa, is that now valid for the rest of the world?
No worries. So trademarks are territorial in the sense that you need to make sure that you are registered in the country in which you're asserting rights. That's just because that it becomes a bit difficult if I register a trademark, let's say for Senna in South Africa, it becomes difficult for me to stop someone from using Senna in Brazil. It becomes a bit unfair only because your rights are exclusive to the country with which you're asserting the rights. Now, there are exceptions to that rule, one of them being well-known brands. So the likes of McDonald's, Coca-Cola, Colgate, some of the other ones that I've used, Nike, Adidas. Those brands have become so well-known worldwide that if maybe there's a country where they didn't register rights, like McDonald's, for example, before 1995, they didn't have rights in South Africa. Just because of the sanctions, they decided that they won't open a branch, but then someone else had opened a business in South Africa and called it McDonald's. Coincidentally, that someone went on to open Chicken Licken and then go on to have all these amazing trademark case studies, but story for another day. So because McDonald's was so well known worldwide, they could allege in South Africa that, well, we're a famous brand. You can't just let anyone use McDonald's and our McD's logo globally. So if you do want to have protection of your trademark worldwide, you'd have to almost try and file in every country. Fortunately, there's a system called the Madrid system, which is the World Intellectual Property Office, which allows you to file a trademark in Madrid and then designate many countries around the world. Now, the difficulty that South Africa is not a member of the Madrid Protocol. South Africa does its own thing, so you can't designate South Africa using Madrid, but you can file to other countries worldwide, to Australia, the USA, England, EU, and Africa as well. So yeah, I think that covers sort of the territorial aspect of trademark. Copyright is slightly different. If you create a work of copyright, it is enforceable across all countries which are members of what we call the Berne Convention. There's about 100 countries or 70 countries that signed up to that. What it means is if you create a work of copyright in South Africa, for example, like the song The Lion Sleeps Tonight, it would be enforceable in the US because the US and South Africa are both signatories of the Berne Convention, including really almost every country in the world. Their undertaking is to protect works of art to ensure that they are not copied across geographies. It's different for trademarks. Trademarks are very, very territorial.
And then Senna, maybe you can also just touch on the different categories. Because I know like if you want to register a name with SIPC, like a name of your company, there might be other companies with that name, but they won't necessarily infringe. Can you maybe also explain that a bit?
Yeah, so trademarks, when they're registered on the CIPC, are registered in relation to specific goods and services. So what we have is 45 classes, all in relation to very specific goods and specific services. What this means is when you register a trademark, you have to specify what you're using it in relation to. What it means is if I register, I'll come back to my own name. So if I register Senna in relation to Coca-Cola, soft drinks, someone else can register it in relation to beds, because those are goods which are in two different worlds. They're worlds apart. It's not like they'll be competing with each other in trade. What the purpose of that is just to ensure that people don't monopolize names across all goods and services, but to also encourage innovation and competition. So one of the reasons is so when you file your trademark and when we do our searches, it would be taking into consideration the specific goods in which prior similar marks are registered in relation to. So that's goods, services, and so forth.
Yeah, are there any
Cool.
questions relating to IP? Okay, I don't see any in the chat. Senna, I just wanted to ask, so in relation to copyright, so you said that you can use inspiration from other people's work to create your own work. How do the courts sort of view if something is very similar to someone else's work, but it's just changed slightly, like different colors are used, but it's the same sort of design and materials used? Like how does that kind of work?
Yeah. So well, maybe I'll deal with similarity with regards to trademarks, and I'll deal with similarity in regards to copyright. So with trademarks, typically what our courts will try and do is do an overall impression similarity of your goods and as well as the trademark. So it's first take into consideration what the mark is. If two people were to walk into a Checkers or a ShopRite and they were to see two trademarks similar next to each other, would they think that these are similar? Now it's the same with e-commerce. The question then becomes, if you're a user on Takealot or ShopRite or whatever online, if you see these two trademarks next to each other, what is the likelihood that you would be confused? Now that's the question judges would ask themselves in trademark law, just in trying to differentiate the two brands of origin. When it comes to works of copyright, so let's say you have created a song or you've written a book. I'll mention the Harry Potter books. So J.K. Rowling wrote the Harry Potter book, and then I think it was then adapted to a movie. Now that is a clear adaptation of her work because it's the same characters. It's not original, it's based on her story, and then they made it into a movie. And then every book that followed after that is based on her story, her characters. So that's an example of someone who maybe even if they're adapting the Harry Potter books, if they're using the same names, the same characters, the same main story, it's ultimately copyright infringement. Or if it's a song, if you've taken the same melody, the same lyrics, the same, I don't know, structure, hook, melody, all of those things, courts will assess it on the basis of, does your work deviate enough from the original work for it to be its own original work? And what they look at is substantial effort that you've put in it. We call it the sweat of the brow test. So you've worked to the point where you sweat your brow. And in that regard, then typically if your work is significantly different from a previous work, then you would be able to, you'd be able to claim that it's an original copyrighted work. So those are just two examples of when, when it would be infringement. Just going through the comments for a question. What happens when now AI has become a part of the creative aspects? Can people trademark or copyright the generated output? So the AI dilemma is something which I think is currently unfolding and it's currently happening. There's a story that happened very recently. I'm not sure if anyone is familiar with Zakes Mda. He's an author from South Africa. Zakes was involved in if I'm not mistaken, a class action lawsuit very recently in America. So what had happened is there's an AI tool that had taken a lot of works, previous books authored by different authors over the years, and then used those books to train their AI tool. And then subsequent to that, create and generate new work, and then train their models, which then, when you're now using ChatGPT or Perplexity or any other sort of AI tool, Gemini, whatever it is, oftentimes that tool has been trained by works of copyright, usually books, novels, articles, textbooks, anything published by anyone. So if Taryn, for example, writes an article on the Legal Ninjas website about contract law or the needs for small businesses when setting up, or what a startup can do when it's setting up a business or getting started. Sometimes what AI tools would do is scroll the internet for all of that information and then train their models and then present it back to you. So Zakes is involved in a lawsuit where I've forgotten the name of the AI platform, but what they had done is they'd taken all of their works, used to train their models, and that was found to be copyright infringement, because ultimately you need a license to use work that belongs to other people, especially original works of copyright. So I think the AI thing is still happening. I think there'll be a lot more regulation. There'll be a lot more court cases, because I think a lot of the LLMs are using copyrighted works to train platforms. And that's why it's important to maybe specify specifically that your work is protected by copyright, just so that if it's infringed by someone, then you have options. Not sure if that answers the question.
Bruce, you have a hand up, maybe.
Hi, hello everyone. Thank you so much for such an informative session. It's really helping a lot. I just want to ask something in the context of my business. So, I just oh sorry.
Hello.
Hello. Okay, anyway.
Cool.
Hello.
And Josh,
Hello.
mute, please.
Hello.
Yes, sorry,
Hello.
I didn't. Yeah, can hear you. So I didn't catch the previous question.
Yes, no. So I want to ask something in the context of my business currently. So okay, so currently we've made herbal smoothies, and it's not a thing yet where people sell herbal smoothies. And I've contacted a few lawyers, and they've told me that we can't patent the ingredients because everybody has got access to it and it's nature's ingredients. And then the fact that it's a smoothie, they're like, okay, but people can also make juices, so we can't patent that. So I was advised rather to keep the recipe a secret and to build on the brand. And the example they gave me is, for instance, Coca-Cola and Pepsi, is that both of them sell cola. However, Pepsi's cola tastes different to Coke's cola. And then they told me to go that route. Is that really the only way I can approach this, or can you advise on what other strategy I can use?
Yeah, so typically patents would protect very new inventions which involve an inventive step. Typically with foods, it's very difficult because a lot of recipes have been disclosed over time, and they're often not novel, and they're not being capable of applied in trade or technically, which is one of the requirements for a patent, which is also complex. I can explain it another day. But now in terms of protection that you can seek, that's something we can definitely maybe discuss offline in terms of the specific detail. But the Pepsi and Coca-Cola examples are good in terms of just keeping the ingredients a secret. I think it's something I mentioned in the earlier slides that's how KFC as well. We kind of all know what the spices are, but then they keep them such a secret because very, very, very important that they don't leak or no one gets access to them. And there's maybe scope to protect it via copyright, but then that's something we probably need to go into a bit more detail, specifically just maybe via a separate phone call, I think.
Yeah, so on that note, I've just put on the slides also our contact details, so you can check out our website, phone number and LinkedIn if you do ever want to contact us with questions about these topics.
Thank you. I will contact you.
Yeah.
Are there any other questions at this stage?
I have
Okay.
one more question for Taryn.
Sure.
Remember on your slides, you were talking about the NDAs, about putting it in your contract for like just putting it in your contract as a standard procedure.
Yes.
So when because now we're looking at having talks with investors in our company, do we have to put an NDA saying that they can't disclose whatever we do in the business, or is it ethical that I still don't tell them the recipe too?
Yeah, so that's a good question. I think because they're new people that you haven't had dealings with before, and you actually probably already you don't have a contract existing with them, you're now discussing the idea of doing business with them and for them to invest in your business. That's when an NDA is good. So that's the ideal situation to use an NDA. So you would say to them, look, I'm coming to present my idea to you. I don't want my idea to be stolen, basically. And I'm asking all potential investors to sign an NDA before I come and chat to you about my business. And then you ask them to sign an NDA. It's very standard. They shouldn't have an issue with this. And that's just a good way to protect yourself upfront. But I also wouldn't then go into so much detail at the meeting. Just from a practical point of view, I wouldn't go into such detail that they actually have the recipe. I would rather say, like, give more vague, overarching stuff like what differentiates our smoothies. It's because we don't just use fruit, but we also use herbs, and these herbs have medicinal qualities and blah, blah, blah. So you don't have to say, like, we use this herb and this ratio. Like, they don't need to know that. They just need to know how much are you selling. What do investors care about? They want to make money, right? They want something that's interesting, novel, and that's going to make money. So think about, from their perspective, what do they need to know to be able to invest in your business? You don't have to tell them the recipe.
Thank you. Do you think the investors of KFC know the recipe?
I don't think they do, hey? I know
I
with
don't think
Coke,
they do.
yeah, Senna would probably be able to tell you more, but I know with Coke that there's probably only like 2 people in the whole company that know the recipe.
Yeah, they're not allowed to be on the same flight. And then something like that is very, very fun stuff. And then when a Coca-Cola employee tried to leak the recipe to Pepsi, the Pepsi execs immediately called Coke to have that person arrested. So it's something that
Wow.
they take very, very seriously.
Sure.
Thank you. Thank you for that insight.
And also, what is your website? Because I want to try these smoothies.
I'll type it in the chat for you.
Okay, cool.
Thank you.
Is there anyone
Great.
else who wants to ask a question?
All right, so it's 11:30. So this is it was good. Thank you so much. If there's no more question, please feel free to send a question to us or directly to Taryn, and we will share. And yeah, so we look forward to seeing you at the next legal session with Legal Ninjas. And yeah, so we really look forward to this. Yeah, thank you so much.
Madeline, sorry, just before we go, can I just ask that if anyone has any ideas, like you said before, any ideas of what you'd like our session to cover next time, then just send those ideas to Madeline, because it's also sometimes difficult for us to know what is the most relevant topics for you guys.
Great. Yeah, if you have any idea, please put it in a chat now or feel free to drop us an email.
Cool, thanks,
Thank you
guys.
so
Thanks so much.
much. All right.
Bye.
Thank you. Bye for now.